Hi, today we're going to discuss about how the Congress is not acting at all. We sent these congressmen to pass the legislation. Among other things, that is their main task for them to do. They are actually not doing that. They're dilly-dallying it, they're making exceptions, they're just going around, but they're just not putting the bills to vote. And the main bill that we are interested in is the immigration bill. It's been sent to the Congress, it's there, it's sitting, they're split into pieces, they did all the drama, but they are not putting it to vote. Now, the Biden administration said that he is going to pass the immigration, he's going to introduce the immigration bill. He did introduce the immigration bill, but the congressmen are doing nothing on it. They're not acting on it, they're going around. There is a House of Representatives. They need to put the bill in there. Then they need to vote. If you like, you vote for it. You don't like, you don't vote for it. If you want amendment, you try to pass. But don't just not put it out in there. They're not putting the bill at all, and that is the biggest frustration causing so many millions of people are waiting for the Congress to act, and they're not acting. One of the main reasons why they don't act on these bills is that if they vote in favor, a lot of people may not like it. If they vote against it, some people may not like it. So to satisfy the requirement, they're just not doing anything. In that way, they don't have to go to their constituents people and tell them they voted this way or not. This is the laziest thing that they can do. Their only purpose, the main purpose is for them to pass the legislation. They're not doing it. Emily, any comments on it?
Yeah, we were hopeful that with the Biden administration, he's been through this dance before under Obama, and obviously immigration comprehensive did not pass at that time. So we thought, maybe we learned some lessons and we'll try something different. Now, yes, he did try something different in bringing this immigration bill very quickly after taking office, not waiting until the end of his first term. But now Congress and the Senate are just not on board and not moving forward with anything right now.
I've been, as an immigration lawyer, been there for more than 25 years. Emily, this is the most frustrating. They don't do this way, they don't do that way, they dilly-dally. They just don't vote on it at all. They're just lazy Congress people, though. The parliamentarians in United States are the worst that I've ever seen. We are in the presidential system of the government. These people are just lazy guys. They don't act on it. We need to put a pressure on them to act on it. Emily, on the 485 processing, though, I just want to explain to people what the 485 processing is there, especially for the employment-based immigration. Once you file the 485 application, also called as adjustment of status, you may be filing with EAD and advanced parole. You may not have filed it. You may have filed with the medical. You may not have filed with the medical. You may have filed with the I-140 already approved, or you may have filed along with the I-140. I'm going to explain the process, though. For the 485 application to be approved, if the I-140 is already approved, that's good. If the I-140 is not approved, you file concurrently I-140. The I-140 has to be approved for the 485 application to be approved. If you have already submitted the medicals, that's good. If you have not submitted the medicals, you must either interfile by submitting it later on, or you may receive an RFE to submit the medicals. If the medicals are not done, they are not going to approve the 485 application. Now, the third condition is that the biometrics must have happened. They have to check whether or not you are an undesirable person based on the criminal background or anything that may hit on you. So the biometrics have to be done. So I-140 has to be approved, biometrics have to be done, the medicals have to be submitted, and if the final action date, once the final action date is current, then comes the time of your adjudication of the 485. Now, in the interim period, they will adjudicate your EAD, advanced parole. Even if you have not have your I-140 approval, the EAD and advanced parole could be approved. Now, for the people who filed adjustment of status in the October of 2020, October, November, and December of 2020 though. The State Department said that there is a good chance that the final action date might become current by the month of September. So we are expecting a lot of movement every month under the EB2 and EB3, particularly for Indian nationals. The priority date is expected to be moved very significantly in the coming months. So if you have downgraded the application, we recommend that you do the premium processing. If you have any travel plans going outside the country, I'm a bit worried about the biometrics. I don't want you to miss the biometrics. If you miss the biometrics, you may be able to postpone it for one time. Sometimes they're giving a hard time in postponing the biometrics. Previous to pandemic, it was very easy, but once the pandemic came in, it's not easy to reschedule or go at any time you wanted to, unlike previously. So you may have to, please be watchful if you have any travel plans. I want you to give complete importance to your biometrics, because if you don't have the biometrics, they will not give you the green card. Anything then you want to add, Emily, on the 485 processing?
I've seen a couple of questions asking about the medical exam. Is it better to submit it at the time of filing, or wait for the RFE, or do the interfile request before receiving an RFE? There's lots of rumors out there. Some people say, oh, if I do the interfiling, it's going to slow the process down. I've not really seen that. The RFE is what slows the process down, because they're not going to act on your case until they receive the response to the RFE, whereas interfiling, it just gets it from the lockbox or service center mailroom into the file. So when the officer opens the file, it's there. I don't see how that would slow that process down. So yes, you can submit it at any of those stages. Any of them is fine. As far as which one is fastest, I don't think the medical has much bearing on it, other than not submitting the medical at all is going to slow the process down.
Emily, there's a rumor that I hear many times, that premium processing, when you do it for the I-140 or the I-129, tends to get more RFEs, tends to get more approvals. Is there any truth in it?
No, I think that is a rumor to not have the process happen as quickly as maybe the employee would like when it's coming from the employer side. I think that our experience with premium processing is, if there's going to be an RFE in premium processing, that same RFE would have come in regular processing. Same with denials. We don't see any increase in the chance of denial simply because the petition is premium processing. So I'm a fan of premium processing. I file a lot of my filings that way, and don't really see any difference in the quality of the outcome.
One thing, Emily, a lot of the selection of the process of the lottery occurred. We don't know there will be more people that will be selected. But if somebody is not selected in the lottery, what do you suggest them to do?
Yeah, if you haven't been selected, we're not expecting to get more selections right now. If there is a second lottery run based on last year, that would likely happen in later in the year towards the fall, and you'd be able to file at that point. So if you're running out of options from an F1 standpoint or your current status, it's time to start looking at Plan B. What options are available? If you're in F1 and you're coming to the end of that program, you can always re-enroll in school at the same school or transfer to a different school. But we don't recommend these schools with the day one CPT. We've talked a lot about that and what the problems are with these programs. If you want to later have the opportunity for OPT or CPT, valid CPT, after you've switched programs, you need to go up a degree level. They don't allow you to complete a second degree at the same level and then later get OPT again, so keep that in mind. You can file a change of status to any other type of visa that you might qualify for. For example, if your spouse is on H-1B, you could file a change of status to H-4 and then hopefully at some point be eligible for the H-4 EAD if your spouse is going through the green card process. You can look into the idea of a cap-exempt H-1B employer. This is for nonprofit organizations that are affiliated with a university. they don't have to go through this cap, and so they can be filed at any time. And then if you're married to a U.S. citizen, you have the option of proceeding towards the green card. The main thing to know is that you can, if you weren't selected this time and your employer is willing, they can submit again for you next year, even if you're no longer in the country. You don't have to be in the U.S. to be entered into the lottery. And if there is a second lottery this year, you don't have to take any action. You're automatically included in it. The current submissions will be part of the second lottery if there is one. Do we know if there's going to be a second one? No, because number one, we don't know how many petitions were actually selected. We don't know how many were actually submitted. So we don't even know how big the pool was to start with. We don't know how many petitions are going to be filed, but how it works is if USCIS doesn't receive enough filings based on the selection so far to fill up the cap, that's when they'll be doing a second lottery. So all of that is kind of up in the air because we just don't know how many people were submitted and how many were selected.
Hanmat Kumar from YouTube has this question for his friend. If the person is working for company A and now a company B is filing a concurrent H-1B, does he need to disclose this information with company A? Under the immigration law, he is under no obligation to disclose the information that he is concurrently working for company B. He further asks the question, does he need to mention the details about company B in the labor certification or green card application? Yes. In the labor certification application, you are under the obligation to mention that you have worked with company B. So that is definitely something that you need to take into consideration though. This question Naveen is asking from Facebook, how come unused visas will go to India? Majority of each country has a cap limit. This question came several times. I want you also to involve in it, Emily, to explain that as we know that 140,000 green cards are there for everybody, and if the 140,000 gets filled out, there will be a 7% cap. Now, please note that the 7% cap does not come into picture until the entire 140,000 gets filled out. If the 140,000 does not get filled out, if it does not get filled out, there is no 7% cap. If it's only when the USCIS and State Department feels that the 140,000 is going to fill up, they will use the 7% cap. So what happens is that when the extra 100,000 green cards that were added starting from October of 2020, and maybe extra 135,000 will be added in October of 2021, what will happen is that, remember I said, if the entire quota is not getting filled up, there is no 7% limit. So, according to the demand though, if you look into the priority dates of EB1, EB2, and EB3, for the other country nationals, it's all empty. There's nobody there. There's nobody there waiting for getting the green card. Since there is nobody there, we are not expecting 275,000 green cards to be used by the other country nationals. There'll be a lot of leftovers. They are leftovers in the 140,000 itself. If they are leftovers in the 140,000, the entire 135,000 that are going to come next year are going to be taken by Indian nationals only. Now, there are some slight exceptions. The reason why I say Indian nationals only is that then once they look into the wasted green card, the people who are not, the other countries are not using the green card, let's say they are 150,000 green cards, extra green cards, then they will look into who are the people who are waiting for a long period of time after giving the 7% to Indian nationals. Then there is nobody else, it's only Indians. To an extent, there might be some Chinese nationals, but a majority of it, if not most of them, will go to Indian nationals. Correct me, Emily, if I'm wrong.
Right, exactly. All those extras goes to the earliest priority date, which is generally going to be Indian nationals.
Are there any other nationals who have been waiting for a long period of time? except barely one here, one there who did not apply for the adjustment of status from other than China.
No, everything's wide open.
So that's the reason in 2020, starting on 2020, October to September of 2020, a good number of Indian nationals are going to get the green card. And a good number of green cards will be given to the Indian nationals starting from October 1st of 2021 all the way to September 30th of 2021. So please be geared for it. I've been having some TV show last weekend. I'm very surprised, Emily, that some of the people, they don't now understand what a green card is. Because people like you and a lot of other good people have told that it's going to take 108 years to get the green card. Then comes the Cato institution that says 150 years to get the green card. So now they're like, what is green card? And they're not prepared for it. So we, at this point of time, expect the priority date to move very significantly because of the change in the way that the immigration numbers are counted. When the family green cards are not used, they're going to fall into the business immigration. That's the reason why we are having it. So in other words, this COVID has been a boon for some of the employment-based green card applicants who have been waiting for a long time. Not that I want it, but that's the way it is designed in the law. If the family immigration visas are not used, they're going to fall into the employment-based. And if there's nobody else there to use, there is no 7%, Indian nationals will get most of the extra green cards that will be there.
Amit from YouTube got his perm approved under EB2 and wants to know if he can file both EB2 and EB3 I-140s. Yes, absolutely. If your employer is willing to do that, you can file in both categories. Generally, an EB2 perm does qualify for both EB2 and EB3, and then you can file the 485 with whichever one becomes current first. Sachin from Facebook wants to know, how critical is the client letter while going for visa stamping in India? If it's something that if it's not supplied, can it result in problems, and what kind of problems? Yes, it can result in problems if you don't have it because of what we call administrative processing, or 221G. So you can appear for your interview, everything looks great, and then you don't have that letter. You're going to get a slip of paper that asks you to submit that letter. You could turn around and submit that letter 24 hours later. Guess what? Your case is going in a separate pile of files that are awaiting administrative processing. It might take 8 months or more for them to finally get back around to your file and look at that letter. Then they have to reach out to the client, make sure that the job is still available 8 months later. You might lose the job while you're waiting. So yes, it is quite important to have that document if you're going for stamping and you're working in a third-party site.
Siddharth has this question: when do we expect normal H-1B stamping services to resume in embassies in India? That requires that I must be a COVID expert. Right now, it seems that the administration here and also the administration in India, Indian government, sometimes, even though the consulates and embassies don't have to, follow every rule and regulation of India, they normally do respect the Indian government and will follow most of the things. The local rules, they'll try to follow as much as possible, though. So at this point of time, the embassies are adhering to the rules of the COVID. The CDC guidelines here in the United States, they will adhere to that. They will also adhere to the Indian government rules too. So that's the problem. I mean, it's very hard for us to predict it, especially telling an immigration lawyer to predict when the COVID will be over, when the vaccinations are going to be and how far the vaccinations are. That's something the immigration lawyers are not that well trained in. Especially I'm not trained in that.
Casey from YouTube wants to know, can we file the H1, H4, and H4 EAD extension in premium processing, leave the country, and come back with the H4 approval to cut down on the processing time because the EAD was already filed? Possibly. The trick here is if you leave before the H-4 biometrics notice has been sent and you're outside the U.S. when that biometrics notice comes, they'll eventually deny the H-4 for abandonment because you didn't appear for the biometrics. That H-4 denial is likely going to trigger the EAD to be denied because it was filed based on the H-4 extension. So you may want to consider filing the H-1B alone in premium processing, having the H-4 spouse exit, get the H-4 stamp and come back, and then file the EAD. This all assumes that you can actually get the visa stamp in a relatively short period of time. So you'd probably want to make sure that you qualify for Dropbox for your H-4 visa, because if you need an appointment, you won't be able to get one anytime in the near future.
Hassan Khan from YouTube has this question. Do I need to file a I-140 premium processing? I heard that USCIS is not accepting premium processing. You don't need to file I-140 in premium processing, but here is a question for you. If you don't get an I-140 approval though, even if the priority date is correct, they will not give you the green card. They cannot give you the green card. So it's absolutely important for you to get an I-140 approved before they issue the green card. Yes, you are right, there are some premium processings that are getting rejected, but that doesn't mean that your application has been denied. They're just not accepting the $2,500 that you send. So what we do when we get the rejection, we refile it again, most of the cases get accepted 2 or 3 times. There are some cases that took like 7, 8 attempts for us to get them accept the premium processing though. We don't know why they are accepting some, not accepting, because we have seen all kinds of things. We keep on sending, and they will get tired and they're accepting, they're taking our $2,500. Now when they reject it though, your money comes back. Your application stays as it is. So there's no loss for you. You know, I know lawyers charge a little bit administrative fees to file it, especially they have to incur the FedEx and other expenditure. But those charges are not that significant enough. If I were you, I would bear them and file the premium processing. Question that is coming up is, can a H4 kid, child, take internship, whether it's for profit or non-profit? Can you explain it? This question is coming from Rakesh from YouTube. Here is the problem though. Any internship, paid or unpaid, is not allowed for H4 person though. Unless they have an ED, since it's a child cannot get a H4 EAD. Any internship, unpaid or unpaid, is not allowed. The reason is that normally internships are for the people who wants to advance their careers. For example, Emily, before she became a lawyer, she was in the law school. So she joined us as a law clerk. The reason why she joined as a law clerk is she wants to enhance her skills so that once she graduates from the law school, she's going to join some law firm and this experience is going to gain. So anything for your own personal profit, it's not allowed unless you have a work permit. In your case, the kid does not have a work permit. Now, if they want to do some charitable activity, completely not related to the furthering of the profession though, then it may be allowed. For example, if they are going to a religious church, temple, they're doing voluntary jobs, serving the food or something like that, do you expect them that they have intention that they will be experts in serving food? I don't think so. So those kind of activities are allowed. Let's say if they're going to tree plantation, or do they want to be an experts in tree plant and want to become most probably not. I mean, unless they have their career goal to be a tree planter, they will be allowed to go to do this for a non-profit organization. They can do a voluntary job for that. But internship for a H4 kid is not allowed. Unfortunately, it's not allowed.
Prashant from YouTube wants to know, after the 485 biometrics are complete, if we travel outside on H or H4, does the 485 get abandoned? So there's a provision specifically for H and L visas, so this covers the H4 and the L2 as well, that if you have a pending 485, but you're in H or L status in the US and you exit and come back in your same H or L status, the 485 is not abandoned. Normally we tell people if you have a pending 485 and need to travel, you need the advance parole first in order to avoid abandoning the 485, but for H's and L's, if you're in H1 status, when you leave and you come back to H1 status, that does not abandon your 485.
Ratnakar Madhurity has said, in old days, Reddy Newman PC said that I-140 premium processing will get RFEs rejected. That is right to an extent, Ratnakar. What you said was that, especially in the month of September, in the month of October though, we have said very clearly, do not file premium processing though. The reason at that point of time why we said was that when we file a premium I-140 application along with the 485 application, when you file the premium processing at that time, when they reject the premium processing, they're going to reject the premium processing, they're going to reject the I-140, they're going to reject the 485 application. And when we send the package back though, there is a chance that the priority date may be backlogged. That's the reason in the month of September and October, or even when we're filing the additional status, we clearly said at that time, do not do premium processing though. That's only because we want the 485 application in there, we want the I-140 application there. But once the I-140 and 485 application is there, you have nothing to lose right now because it's already processed. You have nothing to lose. At this point of time, once the I-140, 485 is issued, this is when we changed our story saying that now you do premium processing. Only in the initial filings, that too with the I-140 and additional status, that's when we said no. But thank you for correcting though.
Question from Facebook, how long might it take to get a decision on an MTR? Is there any way to escalate the case? NTRs can really take anywhere from 2 months to 6 to 8 months. There's no standard processing time for it, so there's no option to do an e-request for outside normal processing time because all processing times are considered to be normal. So really the only way to escalate the case is if you qualify under one of the 4 expedite criteria that are on the USCIS website. Typically, if it's clear government error was the reason for the denial in the first place, that is one of the options, but you have to realize that all processing times are bad right now. So everyone's asking to be expedited, which means nobody will be expedited. Very few people are successful in getting anything expedited, or even if you get expedited, they'll tell you that you have to wait 60 days to get an update or 90 days. It's not a fast track process. So I would not I wouldn't hold my breath waiting for an MTR to be expedited, unfortunately.
Here's a question. Ritesh Agarwal, can I apply 2 I-140s with a single perm? Can I do both in premium processing in EB2 and EB3? What if one gets denied? One thing I suggest you that when you do the premium processing, only do the premium processing for the labor certification that you're filing the original, because you either will file for EB2 or EB3, so use the original labor certification to file for one of the application, do the premium processing for that. The second one, don't do premium processing. However though, once you get a receipt notice, you can then convert that into premium processing. You can. Initially not, later on yes. What will happen if one get denied? That's fine, the second one still be fine. Now let's say if the EB2 gets denied and EB3 gets approved, that's fine. It's not going to make any effect for you. You are still fine. I don't see any problem with that. I have this question from YouTube, which I commonly get these questions. To be predicting the priority date. Here is the question. My priority date is May 2015 in EB3. Should I wait to change the job? That's a tough question to answer. I am not going to answer your question. I was an immigrant before. I've gone through the 485 process. I'm going to tell you, if I were you, with the knowledge that I have, what would I do if I were you? If I were you, my priority date is May 2015. With EB3 priority date, I am not going to change the job right now. The reason I don't want to change the job is, if I change the job, they will apply for the labor certification I-140, and believe me, labor certification process, unlike previously, from the start to the finish is taking approximately 1.5 to 2 years. The entire process. I just checked my emails. We're getting the approvals of the labor certifications that have been filed in the last week of August. Right now, September, October, November, December, January, March, April, that's more than 7 months that it's taking to get the labor certification approval. And also the prevailing wage is taking a long time. And there's a labor certification process the employer has to go to. So 1.5 to 2 years is a long period. We don't know whether the priority dates are going to remain current once the priority date becomes current in October, hopefully so. So if I were you, I will wait until priority dates of the Octobers are released. Then at that point of time, I will contemplate of changing the jobs if I were you.
Sachin from YouTube filed an H4 EAD for his wife, where she already has the H4 valid and now she needs to travel, and he wants to know what will happen to the EAD. So since she did not file the I-539 along with it, she only has to worry about the EAD, and the EAD only requires that you were in the country on the day it was filing. There are no restrictions on traveling when you have a pending EAD for an H4. So no issues at all. She can go and come back and the EAD should be processed normally. Ramamurthy from YouTube wants to know, if we downgrade EB2 to EB3, are both of them valid, or is only the EB3 valid? So in the situation where you're downgrading, you're filing a second I-140 in a different category using the same perm. Both I-140s are valid. They remain valid until an employer withdraws one or it gets revoked. Otherwise, the I-140s both remain valid, and you can file the 485 under either of them. If you later decide EB2 is the route to go because that's going to be faster, your EB2 is still valid and can be used.
Amrita Vaturi from YouTube has this question. Will an L2 EAD automatically get cancelled if the visa changes to H4? Yes, the L2 EAD automatically gets cancelled because you're no longer on L2. Your spouse is no longer an H1B, so the L2 EAD is automatically cancelled.
Saravanan wants to know, my perm was filed this week. My priority date, which is in 2010, is current. Is there any way to get my perm certified faster?
Oh.
No, zero. I can tell you that for sure. The Department of Labor does not expedite any perm for any reason. Not a chance, unfortunately.
Emily, any updates on the class action on the H4 and L2 delays, though?
I don't have any particular updates. I have not seen any kind of response from the government yet. I believe they were planning a preliminary injunction. I'm not sure if that has been filed or not.
The question is that I am on H4 EAD. Can I request my employer to file a perm and I-140 and later on H1B? Yes, on H4 EAD, you can have your employer file a labor and I-140. Perfectly legal. You don't have to be an H1B at all. You can be an H4 EAD and file a permanent labor.
Jagan from YouTube wants to know, can I travel to India when my H1 extension is in process? I'm going to come back before my existing visa stamp end date expires. Technically, you can do that. This is not true if it was a change of status, but for an extension, for H1 specifically, you can leave and come back using your existing visa and existing approval notice, and the extension is not abandoned. However, you're going to have a mismatch in your I-94 number when your H1 approval extension finally comes, because when you re-enter while it's pending, you're going to be given a new I-94 number, and that's unlikely to make it into the file to be listed on your new H-1B approval notice. That sometimes gives issues with driver's license renewal. The government most of the states use the government SAVE database, and so that I-94 mismatch can be a bit of a hassle there. It can be cleared up by traveling again after you get the extension approved.
The question is, Amit Patil from YouTube has this question: what will happen to my green card if I move abroad with the same company and come back on L1 visa? Well, the company can continue the green card process. If you haven't already I-140 approval, you can still go and come back on L1, and if and when the priority date becomes current, the company can file your adjustment of status. We have seen this so many times, not a problem at all. Amit Nagarkar from YouTube has this question: can I change my residence while my I-140 is pending? It is in the same city. Absolutely not a problem. You can do so. You can change the city, not a problem.
Abby from YouTube wants to know, I'm on H4 EAD. Can I ask my employer to file perm and I-140 for me and then later H-1B? Absolutely. While you're on H4 EAD, an employer can sponsor you for the perm and the I-140, and you may not ever need an H-1B as long as you're continuing to maintain your H4 status.
What are the chances of the immigration bill, to be presented to voting? There are multiple bills in there. Emily, how many bills are there recently that you saw?
70 in the House.
70
on immigration.
Immigration. So which one are we speaking? Some of these congressmen, the parliamentarians we call, in the rest of the world, in USA we call congressmen, they just present the bills only to go to their voters to tell them, look, I put the bill out there. That's the only reason why they put some of those bills are. It looks like the whole Congress is working the same way. They just want to not do it all. They don't want to vote on it. They don't want to look to be nice or bad. They don't want to make any decisions on the voting. They just don't want to do any legislation. I don't know what the purpose of it is, why they have been sent there. It's definitely becoming very frustrating. This didn't used to be there 30 years ago. Things used to get passed, especially in the Reagan's time, President Reagan's time and President Clinton's time. Then onwards, it started slowly, and it's getting more worse. The Congress, or the Parliament we call in the rest of the world, in United States, doesn't want to pass any bills. That's very strange.
Rakesh from YouTube wants to know if the 240-day rule still applies to H-1B visas. Yes, it does. The 240-day rule applies to H-1 extensions, where you're filing an extension with the same employer, and while the extension is pending, your I-94 from your previous approval expires. The 240-day rule says you can keep working for that company for 240 more days as long as your extension is pending. However, most people don't need this rule because we do have premium processing. You can get your H-1 extension approved much faster than 240 days, so it should not be necessary to rely on that rule.
What is the trend going on EB1 I485 Biometrics? We're noticing very aggressively they have been requested to get the biometrics. We're also noticing that the EB1 green cards recently, in the past 2 to 3 months, they haven't received any haven't received any request for the interview. And the good news is that their EAD in advance roles are getting denied. Why is it a good news? Well, once they approve the green card, the immigration feels that you don't deserve to get an EAD in advance parole, which I completely agree with them. You don't deserve to have an EAD in advance parole and once you have the green card. So that is going on with the EB1. I'm expecting that the same trend will continue for the I485 applications for the EB2 and EB3, that they will be aggressively pursued for the biometrics, and most probably their interviews will be waived. When I'm noticing the biometrics letters that are getting issued, though, we have filed 485 application in the month of October, when we've received significant number of those people have already received the biometrics. Not all, but significant number. But then when I compare that with the H4 applications, no, they're much delayed. I mean, they're not getting the biometrics as fast as the 485 applications are. So there's a trend. It seems that they're giving more importance to the 485 applications. If they keep on this aggressive mode of adjudicating the 140,000 plus extra almost 100,000 green cards that we got it, maybe some of the H4s will not be on H4s. They will be on green cards. There's a good chance for that. So hopefully they could work more aggressively on the biometrics and also the green cards of the EB2 and EB3 in this year.
Anshuman from YouTube has his spouse's H4 has been pending for a year, which is quite common these days. But his employer plans to file an O1 and wants to file an O3 for his spouse and wants to know if that can be done since the H4 is still pending. So it is possible to file an I-539 for the change of status from H4 to O3 while the H4 extension remains pending. But the I-539, the second one for the O3 status, will likely get an RFE at some point asking for a copy of the H4 approval notice, which you should be getting at some point, and then that can be submitted so she's eligible for the change of status to O3.
Now, questions related to the Dropbox. Can the person be, if they change the company, are they still eligible for the Dropbox? Yes. There were some rumors with regards to the Dropbox that it should be with the same company. When they initially started the Dropbox, they put the condition it should be with the same company, but they removed the condition. It doesn't have to be the same company. Even if you change the company, you are eligible for the Dropbox. Sumit has a funny question, very, very funny question from YouTube. Hey, can I use a Dropbox by not physically present in India and be physically present in United States? Good question, though. No, you have to be outside the country to be eligible for the Dropbox. You can't be in the United States when you go for the Dropbox.
Vina from Facebook wants to know, when do we expect the RFE for the medicals after the final action date is current? Is there any delay from the Texas Service Center? So that's where the processing times come into play. So if your final action date is current, but the processing times still have not reached to your filing date, then it might be some more time before you get that RFE for the medical exam. We're not seeing much of a delay once the final, if you filed based on the filing date and then the final action date does become current, usually enough time has passed to where the processing times are current as well. So we don't see much delay, maybe within a month or two of the final action date. We typically follow up with USCIS on behalf of our clients when that final action date becomes current and ask USCIS to adjudicate the case to make sure that nothing falls through the cracks.
Sumit, even though your question is funny with regards to whether you can get the stamping in India with the Dropbox while you're here, actually, previously, it was allowed. We used to have a State Department where we used to send the stampings to State Department here in Washington, D.C., and get these stampings here without going outside the country. They removed it. Maybe we should, maybe the administration has changed right now, it's becoming more favorable. We should advocate them that they reinstate the passport stamping in the State Department, instead of people going outside the country doing all that stress to get the stamping, they could possibly get the stamping here in the United States. That was only possible when you're applying for the extensions, the passport stamping. It was not eligible when you're transferring from F1 to H1, but for the extensions, just like the Dropbox that we have, we used to have that before. I have done so many of them when it existed. Unfortunately, that is not allowed right now, but we should try to advocate. But good idea, Sumit. We should try to advocate to get the stamping here itself.
Ronald from Facebook wants to know why the delay in the PERM process. There's a couple things. I think number one is the PERM process does not require a filing fee, so they don't have unlimited resources to deal with any surge in applications. So they just deal with any applications that come in with the people that they have. And the other issue is the issue with the prevailing wages that happened in October, where we got new prevailing wages issued, and then there was a lawsuit and they took them back. Well, the Department of Labor had to go back and reissue all of those prevailing wages that were issued with the new wages that were then taken away. So they had to give resources to that, which means fewer resources available to handle the actual PERM filings.
Question from Vikas from YouTube. Is it okay to move to F1 visa while the I-140 is approved? I am currently on L1B visa. There is a question on the I-539. Have you filed any immigrant petition? You need to answer yes to that question and explain. But we haven't seen any denials of the F1 visa because of that reason. Now, I'm not telling that they will never ever deny it. What I'm telling is that we haven't seen any denials as of now. You know, the YouTube, the daily Zoom conference call that we have every day, you guys can come and participate by going to RN Law Group. There's a Zoom conference call that we conduct every single working day for half an hour. If you want to participate, please go to rnlawgroup.com and you can see the timings and how to participate in the Zoom conference call. We get all the information, feedback from YouTube, Facebook. So we haven't seen any denials if the I-140 is approved when you're moving from L1B to F1 as of now. If there is anything, we'll update you at a later date, but right now I'm not seeing it.
Rama from YouTube wants to know what happens if an employer withdraws the I-140 after 180 days of approval. Can we use that petition to file the 485 when the priority date becomes current? You cannot use it to file the 485. You can use it to keep the priority date on that first petition. You can use it to get H1 extensions beyond the 6-year limit, and you can use it for a spouse to get an H4 EAD, but you cannot use it to actually file the 485.
Ankit has this question, Anik Data has this question. Can I go back to India and get F1 stamping? Right, currently I am an H4. Yes, you can. But there's one thing that you have to note it down is that for F1 stamping, you must prove to the satisfaction of the consular officer that once you complete the F1 studies, you're going to go back to your home country, which is India though. Especially since your spouse is in USA on H1, you've been here on H4, we have seen an increased number of denials of F1. But if that happens, of course, you can always come back on H4. That option is still open. But yeah, you have that extra risk of getting the denial of F1 if you go outside the country.
Sunil from Facebook wants to know if I travel abroad while the I-131 is pending, after I turn to the USA, do I have to reapply for the I-131 or the 485 as well? So assuming that when you are in the USA, you're in H1 or L status, and you exit and come back in H1 or L status, the 485 will not be abandoned. You don't have to refile that, but the I-131 can be denied for abandonment and should be refiled after you return.
Can an unpaid summer internship be done while H4 EAD is processing? No. Unpaid internships are not allowed if you do not have the EAD approved. Since it's H4 EAD is still pending, you're not eligible to work, so unpaid internships are not allowed. Yeah, this question comes out. Can a person file H4 EAD basis on the I-539 receipt, or do they need the H4 or L2 approval? No, based on the I-539 receipt notice, you can file the EAD. Don't wait, because it may take a long time for your I-539 to be approved. Don't wait, file it immediately.
Tejas from YouTube says his new company will be starting the green card process in about 6 months, and he wants to know if it needs to be done with premium processing. Well, the labor certification doesn't have an option for premium, so that'll take probably 18 months to get that processed. But once you get to the I-140 stage, you do have the option of filing that in premium processing. Whether it's necessary or not, I think depends on whether your priority date is going to be current soon. So it's helpful to have that I-140 approved at the time you file your 485. It's not mandatory, but it can help speed up the process. Also depends on whether you need that I-140 approved for your next H-1B extension if you're going beyond the 6-year limit. But other than that, a premium may not be necessary for an I-140, but you always have that option.
Question is that can a EB1C green card be filed with a $65,000 salary? Yes, it can be filed with $65,000 salary. There are a lot of other things that need to be looked into it. $65,000 automatically is not disqualified from filing the EB1C green card.
From YouTube, my first EB2 I-140 priority date is November 2010, but it was not recaptured on my second EB2 I-140 or on the I-485 receipt notice. Is this common? How can I fix it? I have seen this a number of times when the second I-140 is filed. The priority date of the second perm is the one listed on the I-140 approval notice. Usually, if you qualify to have the priority date retained, you can contact USCIS. Your employer has to do this to request that it be corrected. It can be quite a hassle. USCIS isn't great at responding to those things. And if it's incorrect on your 485 receipt notice, that's even more common. The 485 receipt notices often do not list a priority date at all, and if they do, they're sometimes incorrect. So it really just depends on, I'm assuming you filed your 485 based on the earlier priority date, and so they must have accepted it under that, but it would be important to verify that, send a letter to USCIS to make sure they have the correct priority date in the file.
Sindhu from YouTube has this question. Can husband and file I-140 separately? What are the pros and cons? Yes, both husband and wife can file I-140 separately. I don't see much cons at all, though. I see the pros because both of you guys can be eligible for the extension of the H-1Bs. I always would like to have an I-140 approval for all the people who are ever been on H-1B. So I don't see much cons in it at all. Question that comes is that from Robin from YouTube has this question: can a person file green card applications from 2 different companies at the same time? Yes, both companies can file a perm at the same time. It is not in conflict. Nowadays, the IT field is in high demand. If 2 companies wants you on a permanent basis, absolutely fine, no problem with it.
Bikram from Facebook has an approved I-140 in the EB2 category and is considering filing the EB3 downgrade now, and wants to know if the filing date becomes current in October, but that EB3 I-140 is still pending. Is it possible to file the 485? Yes, you can file the 485 based on a pending I-140. No issue with that.
A good question from Nehesh. The final action date becomes current, and the child is the child locked in, and after that, because of the processing dates, final action date regresses. What happens to the child age locked in? There are 2 conditions that need to happen for 3 conditions. 1, the adjustment of status must be filed. 2, the final action date must be current. There's a third condition. I want to make sure the I-140 must be approved. So just in case if your I-140 is pending, once the final action date becomes current, make sure the I-140 is done premium processing. If all these three conditions, the child's age is locked. Once the child is locked and you are in adjustment of status, if the final action date goes back, no problem. The child is still not growing. If the processing times goes back, no problem. The child is in a good shape to get the green card.
Krishanu from Facebook wants to know, we got our fingerprinting done and then got an RFE for the 485 for the medical exam. Will this delay the EAD until we submit the RFE response on the 485? No, it will not. The EAD, you get the EAD simply because you have a pending 485. Whether there's an RFE on that 485 or not makes no difference. The EAD will still be processed as normal.
Loha is telling that my lawyer is telling do not interfile the medicals. It's going to slow down the process. I may disagree with your lawyer, but at this point of time, it is not something that I will recommend to overrule your lawyer to do it. If they issue an RFE, you can then submit at that point of time. I disagree with him, but it's nothing like a major thing for you. You can wait until the RFE comes in.
Question for you, Rahul. For adjustment of status applications filed in November at the Texas lockbox, have you been seeing any EADs be issued?
Texas lockbox. Oh, I'm not prepared for that. Next week, I will put an Excel sheet and we'll try to look into it. I can say one thing, that the biometrics are getting done for the November 2, but at the same time, not all the October are done, guys. I looked into it, I went through all the data. There are a lot of October people that are stepped, but in Texas Service Center, I've noticed that they started doing biometrics. But I haven't gone through exactly the calculation when the EAD started getting approval though. I can say for sure the things that were filed in Nebraska in November definitely got their, some of them got their EAD approval. Lockbox in Phoenix, sorry, not Nebraska, Lockbox in Phoenix got them, but the Dallas are a little bit behind compared to Phoenix, Arizona. If the main applicant loses a job, how long it is to find the job? This is for the adjustment of status EAD. I would recommend Woody to contact a lawyer if you don't have a job immediately. There may not be a grace period. There are things that can be done where the family business can employ a person in the similar field. There are ways around it, but it would be better that if you would discuss with a lawyer to come up with those creative solutions. Anything else, Evan?
I think about out of time for today. Thank you all for joining us. We'll be back again next Tuesday. And don't forget, you can always join our daily conference call on Zoom. The details are at rnlawgroup.com. And if you'd like to discuss with either of us or any of our attorneys or your specific situation, you can always set up a consultation with us at rnlawgroup.com as well.
Thank you very much for tuning in.